Alright, just going to do a bit of a trial. Just going to see this. Alright, so the story is my mum, Marilyn in England, passed away in 16th of January 2020. Alright, so a bit of background about her. She's PhD at Queensland University. She was active member of the Australian Defence Force, History Unit, Victoria Barracks, Spring Hill, Brisbane. So when she passed away, it was pretty sudden. She clots in the lung and heart failure. She went within a week or two. Before that, she got put into hospital. She was hospitalised. She was looking after my 11-year-old son. I can't say his name. Really did. So yeah, when my son was with us, we had joint care. We looked after him together. So I was teaching, so I was working. But when I was on holidays, I'd take care of him. But when I was teaching and working, my mum would take care of him. She took him to the Victoria Barracks. She took him to all sorts of stuff, drives and Laylee and uncles and visits and stuff. So yeah, no, she's looking after him. And then when she got hospitalised, I actually had to leave school, walk out of class, drive up to Brisbane, pick up my son. And said his name again. And yeah, we thought my mum was in the hospital for a week or so. Thought she's going to get better. She was okay. She's in ICU. And my son went up to visit her. Then I had my son in daycare down here on the Gold Coast, so I just pick him up after school, after finish class, and then just one day got a call, and she's only had like a day to go or something like that, and she just passed away really quickly. It was sudden, so she left this will. She told me about this one, and there's another. This is called a testamentary document. And she's got another one exactly the same, but she's got a date up here of the 20th of the 12th, 2019. So that's just over 3 weeks before she passed away. So she had this one in her dress drawer apparently, and she had the other one, the dated one, in her purse. So that's two original copies. Obviously I blanked out a lot of information there, sensitive information. And so what happened was, after she passed away, the day she passed away, took all the things back from hospital and went to her house. And she'd already told me this one existed and told me it was in a dresser drawer. My nephew, Benjamin Graham Wickham Smith, alright, let's see if you can believe that name, found this one in a dresser drawer, and then he also showed me the other one, and he found in a purse, the dated one, 20th 12th, 2019. So I didn't know about the second one. But we also had an email from Mum in 2018 that described this document, especially this bit up here. You guys can probably blow that up if you want. But the important thing is, sometime after my mum passed away, Benjamin Graham Wickham Smith took this document from my mum's bedroom, went in the bedroom, alright, took this document back to his unit, and then engaged his solicitors, Nicholson solicitors in Brisbane, particularly Stephen Gray, and they refused to file this document into probate. Stephen Gray called it a wish list. He said, let's call it a wish list. I went, no, because what it is a testamentary document, and all testamentary documents by law have to go into the court for probate. Right? So they refused to file us into probate. They refused to give me the original copy to file in probate, because under the rules, court rules, the original copy's got to go in probate, right? And then the two legible copies are also given to the court as well, alright? So they refused to even give me a certified copy, and this is all statutory law, it's in law. They've got to do all this, and they just refused. So basically, after 6 months, I had to file a caveat, stop them doing anything. Also contact the Legal Services Commission, Department of Justice, Attorney General's office, just got rubbish back from them. I think Legal Services Commission said, he's got his right to an opinion. Well, actually they don't. Under the statutory law, solicitors aren't allowed to put their opinions on the evidence, alright? they can call it a document. That's all they can call it. It's a document, and in definitions, a document can be anything. It can be a computer, email, paper. You can write it on a rock and it's still a document. Anything's marked, right? So also in the rules, any document like that, if it's got handwriting on it, it's got to be a clear copy, legible copy, handed in the court, as well as the original. And that's just a photograph of the original, so that's a clear copy. But if you print that from a printer, you never read that. This is going to look rubbish. You can't read it, and that's what's happened. So I've got affidavits. That's my appeals. I should probably show you actually. Where's the copy? That's actually, you can see that. That is in the appeals book. It's kind of, you can kind of read it. It's not a great copy. But in Jared Mob's copy, again, Nicholson's obviously resigned as representing my mother's estate just before I went to appeal court, and then they said Benjamin Graham Wilson Smith is their client and not to talk to their client, so they've gone from being my mother's client, my mother as their client, to just Benjamin Smith being the client, and then they resigned as his client. He hired another firm, I think it was McGinn's, yeah. And then I had to file an application in court trying to get this document back, the original document, so I could file it in the probate, right? Because that's the law, you can't get away. Concealing a testament document is a serious criminal offence. I think it's 398, 399. So there's concealing a document, stealing a document. Alright, that's in the criminal code. Can't do it. So I had to file an application into the Queensland Supreme Court, try and recover this document and reinstall my mum's solicitors, because basically what happened in the beginning when B. Smith took that document, he also said to me, I've got a friend who used his solicitor instead of my mum's solicitor. And he said, so he couldn't get a quote from my mum's solicitor, and my mum's solicitor later said, yeah, he didn't contact him at all. So by way of tort, B. Smith has engaged his own solicitors to be administrators of my mum's estate. My mistake, my mum's mistake, trusting B. Smith as well, because Mr. Smith and myself are both executors of my mum's estate. So yeah, story short, I had to file a civil action in the Queensland Supreme Court to recover this document and to file a probate, because it's my mum's personal document that was taken from a house, from a bedroom, by B. Smith, kept him in his unit. So as an executor of the estate, I'm supposed to protect the property in the estate, and so they give no reason why he took it, why he won't give it back. So it's not his property, and so after filing a civil suit to recover the property and reinstate my mother's solicitors, which is James White, for some reason, we don't know, because I can't get the reasons of judgment from the Supreme Court. They're privatised, it's got an OSCRIP, and so I've got to actually buy the reasons of judgment to go to the High Court now. So we're just doing a High Court application. So we've done our originating application, which turns out Justice Crowe threw my application out, and of course Ben Smith's lawyers had an interlocutory application where they just basically wanted to choose, because Nicholson resigned, they want to choose their own solicitor to become administrator, right? And not my mum's or public trust like I wanted. So yeah, they got whatever they want in court. They got Jared Mobs to come in, and I've just picked holes in his affidavit, and it's just woeful, right? So on that first hearing, Justice Crowe ordered all costs, all Nicholson's and McGinn's costs come out of my mum's estate. So that was about $80,000 so far. Alright. So I filed an appeal against that because basically in Justice Crowe's orders it said if anyone wants to file an application to have not this document but B. Smith put up a blank document with no writing on it into his affidavit, and I got served an affidavit that wasn't signed or sealed for B. Smith, and I don't know where he got this blank document from. It's code obviously because this one says my will from computer my will saved from computer to a USB. So B. Smith having this document in his possession for like 9 months. Obviously they've read that, and so he's gone into my mum's computers and USBs, and he found a document, and he's obviously printed out a blank one, obviously to me, and put that in his affidavit, knowing that he's got the original document. He didn't copy the original document, put it in the affidavit, he put a blank one in. So Justice Crowe ordered that anyone that wants to file for probate, file it from the blank document of B. Smith's affidavit, alright? Completely ignoring the fact that there's all these other documents. So your computer and USB, the documents as well. And also we get an email referring to these documents as well, so that's another document. They're all testamentary documents in law. So yeah, we're going to High Court now because the appeals court completely ignored the fact that the document exists. So Justice Crowe did not even call this document into evidence, right? Didn't say, why did Ben Smith go into my mum's surgery? Why did he take this document? Why wouldn't he file it into probate? Or why wouldn't he give it to me to file in probate? And why wouldn't his solicitors give me a certified copy? So none of those questions being asked of the judges, right? That's 4 judges. That's the original judge, Justice Crowe, and the 3 subsequent appeals judges. Just ignore the fact. I even asked the appeals judges, why don't you call into evidence this document and read it for yourself? But they just declined. So that's an error of evidence, error of law, error of fact, because you can't conceal documents. That's in the law. That's criminal code. It's 398, 399. There's a whole bunch of draft of other laws and stuff like that. So the behaviours now they're filing in High Court under misbehaviour in incapacities of the judiciary. It's in the Constitution, so it's a constitutional matter. And so it's not going on. So basically from the appeals court, they awarded costs against me with, I don't know what's going to be yet, it's probably another $80,000, $120,000. So we're already down nearly $200,000 from the estate, just because I filed a civil application to recover that document as is my duty as an executor. Right? And so instead of getting that document to file in probate, we got $200,000 cost against us. So I'm just doing what I'm supposed to do, doing the right thing, and it's just what I'm saying to people. I'm doing this as an educational thing. Right? It's nothing, not here to defame anybody. This is the facts. This is all on public record. You go to the court. It's got a call number on it. Yeah, call number. You can go in public court and register. You look it up. Have a look for yourself. It's not a problem. So all these names and people like Jared Mobbs and Stephen Gray, Nicholson solicitors, Benjamin Gray and William Smith. It's all in there. It's public record. So I'm not doing this. I'm doing this so the public can, understand that just by filing an application, trying to use the public courts to public service, don't expect the judiciary to actually abide by the rule. Don't expect them to even look at the evidence, and that's in this case they didn't even look at the evidence. They made rulings and orders. Didn't use the original copy. That's both. The originating judge, Justice Crowe, Didn't even look at it, didn't want it. The same appeals got a certain surrounding. You want, why not call into the evidence this document and see for yourself? And just decline. So both the appeals court and the original made judgment and orders without even looking at the evidence. And so it's a very simple thing. You've got documents, you file them in probate. That's the law, and it's in the rules and it's in the criminal code. So got to go to High Court. Just starting that application, trying to get the reasons for the judgments from these guys, from the appeals and the originating judge, but the Supreme Court have put them into Auscript. So basically, I've got to try and buy the judgments from Auscript. These are public records, public documents, and we have to buy them to do a High Court appeal. So that's where we're at the moment. We're just starting to do our High Court appeal. So this appeals judgment, that was the 19th of May. So we've got 28 days to file a High Court appeal. So if anybody knows about filing High Court appeal, wants to work with this, let us know. It's great. I'm also going to start a patrons page, because hopefully this is just the first of a documentary on this matter. For the public, need to be warned. They need to know that, quite obviously to me, they can't trust the judiciary, can't trust the government, the government, like Anastasia Palaszczuk. She got a notice that this is going on. Right. Chief Justice Catherine knows, yeah, she knows, she's aware, and there's just a whole lot of other stuff on the side things as well, like the registry are not processing the documents properly and doing all sorts of blah blah as they do. So yeah, all right. Hopefully we can educate the public and we can straighten out our government, and especially the judiciary. Everyone knows you can't trust the lawyer. It's common knowledge. Everyone knows you can't trust the government. Common knowledge. And what is a judge? Government lawyer. Okay. So thanks guys. Thanks for listening. It was a bit of a rant, and I'm going to review it and see, might do it again. So this is our first take. Okay. Cool. I'll just zoom in for you so you can read that better. There we go. I will saved from computer to a USB. And so, yeah, we're going probably 15 months now, just trying to recover that one document and file it into evidence. And it's cost myself and my mum's estate nearly $200,000 court costs. Just obviously to me, that's just crazy. Alright, it's not hard. One document file, easy, right? Simple, basic administrative justice. And now we're going to go to the High Court. Still trying to get this sorted. Alright, thanks for listening.